But if you're prepared, if you so choose, since you have time, if you so choose, you may make a summary argument or a closing argument or something of that nature. And then Mr. DeSisto as well, and because you would have the burden on the motion to intervene, I believe Mr. DeSisto should go first.
Yes.
If you want to, Mr. DeSisto.
I'm not going to be long. I appreciate the opportunity to address the Commissioner on this. Thank you. If you don't mind, I'm going to incorporate, due to the time, our memo on this. I don't want to repeat it. I think we've cited the law on it.
And just so everyone is aware, we mentioned that there were filings. All of those filings will be part of the official record of this administrative procedure. All of the filings that have been submitted by parties. So you may refer to any.
All right, I appreciate that. You know, RIDE interposed an objection here, and it may seem odd that we're objecting when there are people that are trying to intervene in the process. So I want to explain that a little bit. When the papers came in, and you might have got this from my questioning, it was unclear as to what the petitioners were seeking, and that makes a difference here in this motion, which is a motion to intervene. So now at the hearing, what I've heard in testimony is that the interveners are claiming some potential harm if the wording of the order isn't changed. And potential harm from a legal point of view is not going to carry the day, and I'll get into that. That's the problem here. The Crowley Act itself, Madam Commissioner, is silent on a hearing of this nature. And so we look to the rules of civil procedure on the legal motion for intervention here, and especially as used in an administrative process. So as I understand my colleague and friend's position, all of the interveners are using RIGL 16-39-2, saying that if they show, and you said this in the beginning, if they show that they're aggrieved in any way, that provides standing. And the fact of the matter is, aggrievement is one element, but I'm advocating to you that we need a little bit more than that. It does not negate the constitutional standing requirements, both for 1639-2 or Rule 24, for standing, and that is an injury, a discrete and distinct injury, unique, not from the whole group, but unique to the people that are intervening, and not shared by the general population, which is the student population and the parents. All great testimony, all accepted, it's all good, but from a legal point of view, I didn't hear any unique injury. I didn't hear any injury that is not alleged to be common to all. And I think that's something that the Commissioner has to take into account when you look at this motion. The law is that the injury not only has to be unique and not common to all, it has to be actual and imminent, not conjectural or hypothetical. And here what we're talking about is the potential if this order isn't changed. In my colleague's brief, it says if the state intervention, if their intervention here fails, there's some harm. And that's why I ask questions like, do you think that the commissioner doesn't have your interest? And everybody, I think, said, no, she does. And so I think that the speculation, or we're speculating, that the decisions that are made under the current proposed order will be injurious. And that, to me, is at best speculating. And I don't think you meet the elements of standing. The Crowley Act itself is a specific legislative enactment that supersedes RIGL 16-39-2. As we all, as the lawyers know, and I hate to talk in legalese, especially with this group, although I think you all get it. I can see that in the faces. But a statute enacted in derogation must be strictly construed. And I'm talking about the Crowley Act. So we must apply it as written. The Crowley Act is what is the authority that gives the commissioner, through the agency, the authority to act here. And the Crowley Act says that, in this case, the commissioner may collaborate with two entities, the school committee and the municipality. It doesn't list anyone else. And 1639-2 can't override it because that's a general statute, general provision. Crowley Act is specific. So I think the specific statute governs the general one. That's in addition to all of the arguments we've set forth in the brief. But I do want to conclude with this, that having said all that, this dialogue through this morning and this afternoon, I think points to another issue of standing, and that is, I think you've got what you want in that order. And I think that's something that you should take into consideration when determining standing. We'll argue this at the show clause, I'm sure. But when I look at this order and I hear the intervenors, I'm not seeing much substantial disagreement, especially with the commissioner's final commentary here. So based on all of that, mostly the memo, I'm objecting to the intervenors here. Most respectful. Thank you.
Thank you. That's good.
Thanks. It's rare that I actually participate in a hearing in which there's such a specific disagreement about what the underlying law provides. And I think that while I have tremendous respect for Mr. DeSisto, that is a misstatement of the law of standing in education matters in the state of Rhode Island. The party that has standing in the state of Rhode Island, and these petitioners, do not rely upon 1639-2 exclusively. In our papers, it's very clear that we're arguing that whether under 1639-1 or 1639-2, that given all of the jurisprudence of standing in education matters in this state, these petitioners meet the standard on a motion to intervene. 1639-1 says parties having any matter of dispute between them arising under any law relating to schools or education may appeal to the Commissioner of Education and Secondary Education, who, after notice to the parties, shall examine and decide the issue at a hearing. This is a unique structure because this is public education. It's not a commercial dispute between two parties. It's not someone suing someone else over a car accident case. This is a place that the public comes to resolve disputes in matters of public education. And in 1639-2, it says any person aggrieved by any decisions or doings of any school committee, and I'll talk about that in a minute, or in any other matter arising under any law relating to schools or education, may appeal to the commissioner and have a hearing. This hearing is happening, and whether or not the community members are entitled to the remedy they're seeking, that's a second question. The first question is, do they have a right to be in a hearing with their commissioner? And I think that answer has been answered consistently since 1896 to say yes, this is a more open forum for parents and students, not for the general public, for parents and students than other courts, than other systems. Any person aggrieved by any decision or doing of any school committee. So, Mr. DeSisto correctly points out, we're not appealing an action of a school committee. But, given this weird turn of events, actually, Commissioner, you become the commissioner and the school committee, because there is no school committee if the order takes effect. And so, we don't have a school committee to appeal from. So it kind of collapses two layers in the process, and it brings us before you. But that's kind of complicated. The first one is really simple. Is there a dispute? And is there a personal stake? So let's go to that issue. Because in his papers and today, on behalf of RIDE, the argument has been that these parents and students have to show that Danielle Rodriguez is different than Maggie Meehan in their claim, and that it's particularized to the individual. That is not what the previous hearing decisions say. They have to prove that they're not like the general public, that they have a personal stake because they're the parent in a school that's affected, or because they're a student in a school that's affected. Students of Hope High, the Rhode Island Parents for Progress, the Coalition to Eliminate Childhood Poverty. These groups had to show they had one or two members who had children in the schools. And then they could speak for parents with children in the schools to say, yes, we think other parents really want school breakfast programs. And we're coming to the commissioner because our school committees are so callous that they think, and they say in the decision, if your parents don't feed you at home, it's too damn bad. And these families came forward and said, no, actually, that's terrible. And you can get federal money to feed these children so they can learn. And so one or two parents in a statewide coalition, not even with all of its members drawn from the city of Providence or the city of Newport or the city of Pawtucket, and not, counting up the noses to see what percentage of the entire community was in that organization. One or two families in a larger group can come and say, because you're the commissioner, it's not like who hit whom with their car. It's like, no, actually, we're repping for the families. I'm a family, my kid is in this school, or I'm a family, my kid is in this district. And that's been enough. That's been enough to get people in front of commissioners. When the students at Hope High came, there were like 10 students. They didn't have to do a plebiscite at Hope High and say, common planning time. It's in our plan for school improvement. We actually embraced it. Like, how often do you see students suing to insist upon an element of education reform? I mean, it's pretty inspiring, actually. And no, you're not going to stand at the front door at Hope High and have 96% of the students put their name and come and ask for a hearing. Those young people, a small smattering of young people, were able to come together, and they had standing to ask the commissioner to enforce the school improvement plan. If we disturb that mechanism, that's a bad thing. We should not mess with that. That's been the way this has been for a long, long time. And I know that you don't want to mess with that because people get to come forward and raise these issues. And Not all those cases worked out in the end for those petitioners, but they got standing. They didn't necessarily get a result. And in the decisions, the commissioner's hearing officers have said, you know, there's only a couple of you, it's kind of weak, but I can't deny that you're different from the taxpayers, you're different from the families out there who don't have kids in the schools. You're different if you're the students at Hope High. You're different from the kids who don't go to the public schools. You have enough of a personal interest in this to come in and be heard by me. I'm not saying I'm going to give you what you want, but you have enough to come and be heard by me. And that's what the jurisprudence of standing is in education laws of the state of Rhode Island. The Crowley Act is actually the mechanism which is referred to in 1639 1 or 2. The Crowley Act is any law relating to schools or education. Like, it's an educational law, and we have a dispute about its implementation. And we're asking the authorized interpreter of education law to interpret the law. And we might get a good result or a bad result, but we get to ask. And that's what this whole structure is about. That's why we have administrative law. That's why we have commissioners reviewing matters of education law. Commissioners get the first bite at this. It can go to the Superior Court, but commissioners get to interpret the education laws of the state. And any law relating to education, it comes to you first. And over a long period of time, parents and students have been able to ask, Commissioner, please interpret this education law. And you are the decider, so if you decide a way that we don't like, everyone knows how that works, right? That's respect. But we get to come and ask you. And that's what standing is about. So the particularized interest, you're a kid in a school in the district that is at issue. You are a parent that has a child in that school. That's why I ask these folks, like, do you go to that school? Does your child go to these schools? Is your whole work as an organization focused on empowering youth in these schools? That's been enough. It's been way weaker for some of these organizations, honestly, in the other cases, so that alarms me that would be eroded. And in the interpretation of the education law, so then we look at the Crowley Act. And the language of the Crowley Act is not in opposition to that principle. The language of the Crowley Act says, there shall be progressive support and intervention consistent with the comprehensive education strategy. It shall focus on technical, in the first instance, technical assistance in improving planning, curriculum alignment, student assessment, instruction, and family and community involvement. That's in the Crowley Act. That's part of the purpose of the act. And so you can interpret it to be that it doesn't mean at this phase, parent and community involvement is the key thing, but it also refers to creating supportive partnerships with education institutions, business, governmental, and appropriate nonprofit agencies, like these groups that you've heard from today, who are serving the very students in the public schools. So yeah, families and students and these student organizations, they live inside the Crowley Act as well. And they're coming and saying, under 1639 1 and 2, we're asking you to interpret the act, and we get an opportunity, just like the other four parties that you named as being parties having standing, we're just as important as them. And not Danielle Rodriguez or Maggie Meehan or Sally or the orgs, but the concerns that they're bringing for the community. The concerns that children should not go hungry in school. The concerns that education reform should not be eroded because the new leader doesn't like the plan anymore. Those were what those other cases were about. So I think that's, I'm pretty passionate about this today because we could take a really wrong turn here, reinterpreting the education law in a way that is not accurate. And I think it's something that is precious and needs to be protected. And then you get to the issue of whether or not what is being asked for would be harmful if it's not granted. Because I've just addressed, are these the right people to be coming to you to ask to be included in a hearing? Do they have the requisite interest? No one wants this intervention to succeed more than the people who came before you today. You know that. And they're trusting you that that's actually what's driving you. They've said that over and over again. This is not an attack on the takeover, on its efficacy, on its timeliness, on its efficiency. That's not what this is about. And I know that it's been very frustrating to have many public pronouncements as a commissioner and feel like, well, nobody is listening to my core message. And I think you heard that, the other side of that mirror today. Like, why are we talking past each other? Because everyone's really on message. Like the young people, the parents, the community groups, they've been super consistent. We support it, we want it, we demand it. We are afraid it will fail if we don't do it together, and not just based on the handshake, which is human and important and the main thing, but also to have an institutionalized mechanism. Because we presented evidence from an expert who literally wrote the book on state takeovers and who said, yeah, there's a significant risk of failure. There's a real risk of harm to these folks. Because everyone's like, don't leave us where we're at. Do not leave us in the status quo. We beg you not to leave us in the status quo. Bring us with you. We want to be on the train. I know there's all these metaphors, but it doesn't have to be fancy. It's very, very basic. The status quo is unacceptable. And actually, the only thing that would be worse for my clients than the status quo would be to have the hope invested in this remarkably weird takeover and have it fail. Because if it fails, everyone else will be gone, because that's how that works. But these guys will still be attending the schools, trying to carve out a life for themselves and their families, trying to do the work. These organizations have been doing this their whole life. It's not like their job, their day job. It's their life. So they're not asking to undermine in any way, but they have standing to request to be part of a hearing. And I would argue that as a legal matter, they have an equal stake in terms of the jurisprudence of standing in Rhode Island on education law to the other parties that were named who have a stake. But they're not enumerated separately in the Crowley Act. Not all of them. And they have interests that have all been discussed. But these guys actually have an equal stake in that and believe that they're a fifth party in the show cause action. You can say, as you then start to take up the questions of should there be any amendments to the proposed order, you can say, I heard all your testimony, and no, you know what, I think I should stand pat with this order. But they have a right to ask you that. This preliminary hearing is about that part of the question. I want to show you a diagram, partly because we made it, partly because I haven't burned all my time yet, but I think it really helps to tell the story. So we have to take down this page. So, we do not have an expensive graphic design staff at our firm. And that is meant no disrespect to our not expensive graphic design staff who's present. Thank you. But, Commissioner, this is what all of our witnesses today are trying to articulate. On the left, you see a series of formal, institutionalized mechanisms that are enshrined in statute, that are known mechanisms. And by the way, we will stipulate they often do not work. No one here is an apologist for the fact that American democracy is just running right along like a well-oiled machine. It's messy, it's difficult, it involves constant daily struggle of balancing of interests, but it's what we got. And when you make dramatic alterations to the democratic processes that we know we have, we've heard some very compelling expert testimony today that that should be done with great caution and care. And when we look at the role of the school board, we look at, these are just the educational pieces of where does the community, the Providence community, not statewide, because minority rights are not respected when the decisions default to majority bodies. So we're really not asking Barrington and South Kingstown what should happen with Providence Public Schools. And I know you're not doing that. But the danger is that with only state actors and no mechanism built in for local accountability, that's formal. You know, that people feel like even if the current staff went away, even if the current implementation went away, that the authorizing document, because it'd have to be a different authorizing document with a different takeover, right? This is the authorizing document for this takeover anyway. That the authorizing document doesn't really lock that in a way that's very reliable and can be legally claimed. And so, you know, these bodies, they have to be subject to the Open Meetings Act, the Public Records Act. Those are real things, like they're cumbersome. I've been a public official and you've been in private practice, and they're cumbersome and difficult, but they're there, you know, that's the best we can do as a society to have ways to have people have meaningful input. Nobody's trying, no one over on this side of the room and our other community members who are concerned and are here today is trying to fill in those colored question marks. So a lot of the questioning from the attorneys today was around those colored question marks, like, well, what do you want? What is that place in the middle? Because we know that the left side is what we currently have, and on the right side, people are saying, I read the order, the proposed order. I read paragraph 4, and there's some discretionary structures there. There's some mandate to do a process, but not a mandate to have a product. And so what I heard, and on behalf of my clients in summation, people are asking to be involved in the design process for the mechanisms of parent and student inclusion. And you may turn to us all in an hour or 20 minutes and say, well, duh, yeah, but we're here today to say, as a formal matter, that's what's being petitioned for. We're not trying to dictate the outcome to you. We're not trying to dictate any particular method or approach or mechanism, like a committee with 12 people with this configuration and these characteristics. No, but to say, we're standing to be here to get this interpretation, and the petition is to fill in the colored question marks so that there's something formal and something legal, so that, like, I could do my job. If that wasn't happening later and it was built in, I could at least go and say, hey, that was in there, and that's part of the authorizing document for this takeover, not the next one or the last one, but this one. And therefore, I could go and ask someone else to, like, make it happen if it really wasn't happening. And whether that was you or another decision maker that was like, yeah, that was a good idea. I mean, we've seen that before. That's what that whole Hope High case was about, was that one commissioner thought it was a nifty plan and the next commissioner was like, yeah, no. So So they had standing, actually, because they had a written plan and it wasn't happening. So there's one other issue I want to address, and that is this notion, which I find really concerning, that by including the most affected, by including students and parents and the organizations that work every day with our young people, that we're re-bureaucratizing. That's just wrong, because that's apples and oranges. And I think that it was said best when Danielle said, you know, we're not bureaucrats. This is not our job. We're not here angling for professional advantage or personal gain. We're actually the consumers of this stuff. We're actually the ones who are being acted upon. You know, we're not here to put in 3 more layers into the procurement process. Get professionals to fix the procurement process, by the way. You know, that's not something that I think you're going to find that the community is like heavily telling you, you know, kind of paragraph by paragraph how to do that. But when it comes to school culture, when it comes to how discipline is handled, when it comes to what is being taught in the schools, the inclusion of ethnic studies, when it comes to the role for police authorities in the schools versus do we ever get some access to counselors up in here? Those issues, those are the ones that people are really seeking to have that formal role in giving input to. And to suggest that the very people who are most affected by it would be like creating a new set of messy, unmanageable, bureaucratic fragmentation. No one wants that, and by the way, no one wants to even show up for that. People are looking for streamlined, accountable mechanisms to assist you in succeeding. And thank you for giving us all this time to explain to the best of our ability a very difficult to communicate concept. And thank you for your patience and kindness in listening to all of this. No one that I've spoken to about this process underestimates the difficulty of this process for a decision maker. And everyone recognizes this is one in, I can't even quantify it, some very large number of very difficult decisions. And you're going to have to slog through each one of them. And thank you for your commitment to doing it.
Mrs. Jefferson?
I do. I just want to, it's on the record, so I want to indulge me for 2 minutes on the legality of the case law. May I address that in 1 minute?
Yeah, you still have time.
Okay. So the one thing I want to say is we do have a disagreement. All of the jurisprudence that you call precious and needs to be protected, I agree with. But those were all single issues in one school, not an entire takeover of a school system. And that's the distinction we've drawn in our papers, but I didn't want to let it go without putting it on the record. So we're not trying to overturn all of the RIDE decisions on that. We just don't think it applies.
I want to thank all of the lawyers and the witnesses on behalf of the Commissioner. I thought it was, and the Commissioner will say something too, I thought it was extremely well done. You both made your times, barely, but you both made your times. I thank you for that. And not only were the written presentations excellent, so were the evidence presented in the oral arguments. And Commissioner, do you have any words?
Not really, other than to thank everyone for taking the time. I do agree that everybody has the right to ask, and everybody has a different opinion. I don't speak for all commissioners. I don't speak for all Latinos. I don't speak for anyone other than myself. And what I have said, I stand by it today, tomorrow, and the day after. We are not moving forward with a plan that does not include the community. have nothing else to say.
What we will do, Commissioner, we're going to take 1 hour break. During that hour period, Commissioner will review what she's heard, and again, review the briefs again, if she wishes, the testimony, and then we will come back, and there will be a decision on the record with respect to the motion to intervene.